the contract. Their sole connection with my client is they say somewhere down the line, my client's got some money. And if you do the cash flow diagram, you'll see that the cash flowed down. Well, I understand where they're coming from, but they don't have a cause of action based on that because of the commixtio defense. We didn't get the money from them. That's what I keep on saying. We got it from the bank. It's not their money. They have no cause of action against my clients. Now,
why was the repayment?
I beg your pardon?
Why was the repayment then?
Well, it's set out in
the was made. So if you are of the view that they have no claim against your client, and your clients there should not have been any repayment on behalf of your clients.
My client
they didn't receive any money from the Department of Health. They received it from the bank, and it's their money. But they repaid.
Exactly correct. I couldn't agree with you more, milady. But the flaw in the reasoning, with respect, is that my clients are assumed to have repaid the money. They didn't repay the money. It was repaid by the company, Matetwa. It wasn't repaid by my clients. Matetwa borrowed the money from my clients and asked to reverse certain legitimate transactions between Matetwa and my client regarding the sale of cattle. That's not a repayment of monies, not some sort of admission of liability by my clients. That was a contract between themselves and the Mateta company. It's got nothing to do with repayment by them. They never repaid anything. It was the company that did so. Now, the company may be criticized, or there may be some cause of action against the company which sits above the line of my clients in the cash flow diagram, but it's got nothing to do with my clients. So the question, with respect, is not legitimately, well, perhaps not correctly posed to my clients. Why did they repay the money? It's based on an assumption that they repaid it. They never did. It was repaid up the line by Mtetwa, the company. The question may be asked by them, but I hold no brief for them.
They've offered an explanation regarding the monies they've received from Mateta.
Correct.
Right. And I mean, I make a finding that there are improbabilities in that explanation.
Correct, Melody. I've read that finding, and with respect, it's based on speculation raised for the first time in reply, and it's best just ignored, because the SIU's case must be made in founding. They're very trite, long-standing principles that you can't make out a new case in reply. So the SIU's case in founding is purely and simply, you've got our money and we want our money back, and it's recoverable. We hear for the first time, as I recall, in their heads of argument on the condictio obturpum causum. And we've demonstrated conclusively that there's no cause of action under the condictio obturpum causum. They then try afterwards in reply to say, oh, well, we don't believe your explanation, and the money came from the other 150 million. All of this is raised in reply, in respect of which there was no opportunity afforded to my client to deal with. That's point A. Point B, it's speculation. Point C, it doesn't give them a cause of action either. Because what is their cause of action there? Their cause of action can't be, oh, well, we don't believe your explanation about receiving the money, because it still doesn't get past the fact that the money wasn't received from the government. It was received by my clients from Mateta Company's bank. It doesn't give them a cause of action. They still have no cause of action. They can criticize my client's version for all they're worth. It's not going to help them if they don't have a cause of action in the first place.
But your client, so if I were to accept that the Mateta payment was not made on behalf of your client, right, which is actually the SIU case, that it wasn't made on behalf of your client, how do you then get around the knowledge of the turpitude argument? Because your client now knows that, your clients know that they received money that is tainted with turpitude. They've got knowledge of the turpitude. How do you get around that argument?
There's no turpitude in getting money from somebody's bank. where the money is owned by the bank.
Okay.
So
you fall on the commixtio principle.
On the commixtio, we fail to see why there's any turpitude involved. But in any event, if the whole basis of the SIU's argument is based on the cash flow, where they have the diagram, the cash flow diagram, and they show a trickle down of monies from the top, all of which is contrary to the commixtio principle. But the second answer to that is they can't rely on the trickle down principle and ignore the trickle up principle, where if they are entitled to rely on the cash flow trickle down notion, they must take into account of the money that's come trickling back up. And they can't do that because the money that came from Mateta would resolve any claim that would lie against the 33rd and the 37th respondents, if there was any such claim, which there in fact isn't. So there's no turpitude in relation to that money. Mr. Curry's submissions with respect assumes that there's a turpitude attaching to money that flows from one party to another party and then to other multiple parties through multiple banks. How can that turpitude survive all of that? Where's the turpitude there? It's debits and credits in bank accounts, and to the extent that money can be said to be owned, it's owned by the banks. We know that. That's the law. So yes, where's the turpitude?
The claim lies against the right to the credit held on behalf of your clients by a bank. It's not against the actual money.
There's no claim against the credit. There's money exists in the form of debits and credits in the bank account. There's no turpitude attaching to a credit that you get from somebody else's bank if someone up the line. Now, Milady, can I demonstrate the proposition how absurd all of this would be if this was in fact the law? If you can trace turpitude to debits and credits along the line, when Shabir Sheikh was convicted of what he did in relation to the arms deal, he got a lot of money. Now, where's all that money? Is that money still attaching to the turpitude of the original?
He was not followed.
Sorry?
I don't know whether that money flowed further down, and I don't know why that money was not followed.
Well, exactly.
Let's deal with facts that have been decided on by way of authorities.
Sure, but I'm trying to.
Example assists us.
Yes, certainly.
We know that the case pending against the former state president in relation to that. So,
okay, I'm trying to. I hear what you say, Milady, and with respect, maybe it's not a good idea to pick on specific examples. So let's talk in general terms. You know, in shipping law, we have something that Milady may or may not be familiar with called a maritime lien, and that's a concept in shipping law where, regardless of the change of ownership of the ship, if you have a category of case giving rise to a maritime lien, that attaches to the ship, and they say it's like an invisible mollusk attaching to the ship. Wherever the ship goes, if you've got a claim giving rise to a maritime lien, you can attach or arrest the ship. There's no comparable concept in South African law or any other law, as far as I'm concerned or aware, where you've got some type of invisible attachment to a credit or to money, whatever you call it, that flows through multiple parties. There's nothing. You can't say that a credit from one bank, after it got payment from another bank, after that bank got payment from another bank, and then somewhere up the line there was fraud or money being stolen. You can't say that attaches to that credit or that money like some sort of invisible attachment, and you can trace it wherever you like. It's just simply unsustainable in our banking law, in our commercial law. So there's no such thing as turpitude attaching to a credit that flows through multiple banks. If you're talking about immediate parties, and if the money, instead of flowing into the bank and being mixed with the bank's all of its other monies, if it was held in an identifiable fund, that's what the authorities say, then you can reclaim it between the immediate parties, or perhaps even between more remote parties, as long as it's held in an identifiable fund. But the SIU makes no case whatsoever that this money, whether you call it money or whether you call it credit, was in an identifiable fund. The money that came from the Digital Vibes contract went into the bank's accounts. It was mixed with all the other banks' money. It lost its identity, and then it was paid out to various people. There's no such thing as turpitude attaching to the money. So when they say attaching, they had knowledge of the turpitude attaching to it, and that gives them liability even after the event. With respect, it's a legal nonsense. It doesn't exist in law.
Anything further?
My lady, yes, just on the other bullet points, my learned friend, Mr. Curry, says that a plaintiff can choose his victim. We don't disagree with him. A plaintiff or an applicant can choose the victim, but it doesn't mean that a point of non-joinder can be taken by one of the victims in respect of persons not joined. So that my argument really is just to demonstrate the illogicality of the notion that Natai is applicable. And we're back to the point that they joined us because they have a claim against us, and they have to have a cause of action if they've got a claim against us. The next bullet point, he says that it can be carried out, it can't be carried out in effect without the joinder. His submission there is focusing on the wrong order. The original order, setting aside the contract and the review, that can certainly be carried out without affecting my clients at all.
Yes, they're not being joined for that order.
Well, exactly, but that's the point. Is we back to the point they're being joined because there's a money claim, and that means you've got to have a cause of action. Then he says the merits are irrelevant at present purposes. That's for the trial court. With respect, that's not correct. We submit that it's a particularly clear-cut case where there's no cause of action. So why must we be dragged through a trial action or an application, extended application, which has nothing to do with us in the circumstances where there's no cause of action? I've already dealt with the notion that SIU can amend after the joinder. That's not the law. They have to set out their cause of action in the joinder, and if they don't have it, they don't have a cause of action for joinder. The penultimate bullet point was he said it's not a final repayment. With respect, I've already dealt with that point already. It is final in the meantime. And
so whether it's final or not final, it really does not affect your client because you've not repaid and you are not liable to repay anything.
Exactly. Well, no. My client doesn't say he's repaid the money. My client says that under a legitimate transaction between themselves and the next person up the line, they have acceded to that person to request to resell the cattle to them and to lend some money. My client doesn't say it's repaid the money.
The original downflow of the money is saying that you're not liable to repay anything, and you've not repaid.
Well, exactly. We're not liable to repay anything, but the money, if that argument was raised at the level of the trickle-down argument by SIU, we say the trickle-down has been met by the trickle-back up. It's come back up from the person above us in the line. There's no admission of liability by my clients in respect of any turpitude whatsoever. As far as they're concerned, there was a legitimate transaction between them. But in any event, the money's been repaid on the cash flow diagram. And then in respect of the costs, with respect, my clients have been left in the position where at the end of this very long application and possible referral to trial at the end of the day, they succeed on the basis the court says there's no cause of action against them in the first place. But we still have to pay for the costs of the incorrect joinder. So we say with respect, another court could adopt a different view in that regard. So in all the circumstances, notwithstanding my learned friend Mr. Curry's submissions, we maintain that there is sufficient here to reach the conclusion that there is a reasonable prospect of success on appeal.
Thank you, Mr. Harper. We're taking a short adjournment until 11:30. Thank you. We may resume. I thought you were done, Mr. Harper.
Yes, my lady, I am done, but I was showing my physical presence ready to hear.
Oh, thank you. Thank you, Mr. Tron. Other counsel, you don't have to come on. I know that you're there. It's 11:30, so we may resume. Thank you.
My lady inquired from my learned friend, what about turpitude, even though there's been repayment by Mateta? Of course, the moment that there is a repayment by Mateta, there's no longer any unjustified enrichment, because there's no impoverishment on the part of the state. It becomes irrelevant. There's a repayment, there's no impoverishment, there's no claim at all for enrichment against anybody who survives that payment. And my learned friend, Mr. Curry, with respect, is wrong. The payment was accepted by the department, and the payment is therefore final. I've given your ladyship the authority. So once there is a final payment, which is a fact, there can't be any enrichment. There's no cause of action. I align myself with the submissions made by Mr. Harper. In this case, they needed to establish a cause of action in order to get a joinder. And in fact, they had to establish a cause of action in order for your ladyship to grant the amendment. Mr. Curry is not correct. My notice says to be appealing against the whole of your judgment and orders. And that includes the amendment, because we say you can't amend into something that where there's no cause of action to sustain the prayer. And so therefore we say, with respect, that your ladyship should grant the leave, subject, of course, to what I've set out about whether leave to appeal is necessary and what the consequences are, depending on what route is followed. I didn't argue it, and my learned friend, Mr. Curry, didn't deal with it, but it is in my head, and I'm not abandoning it. It's my duty as well. Your ladyship knows that it is a point that hasn't been decided fine.
Thank you.
My lady, those are my submissions.
Thank you.
Lady, there are three interrelated issues that I would like to make submissions on. My learned friend, Mr. Curry, stated that there are 15 other respondents who have been joined. The lady must take note of the unique situation here, that these monies have been repaid. So there's no congruency by submission with the other 15 respondents. My lady, on that score, my learned friend states that this is not a payment under protest because of the conditions attached to it. Lady, even if this is so, and that the conditions are found to have no merit, the fact of the matter is the SIU has the money. Mr. Mtetwa says, in essence, he has the money. Please repay the value that I have attributed to the contract. If there is a value that justifies the repayment to Mr. Mtetwa, in terms of Section 172, subsection 1, subsection B of the Constitution, the just and equitable principle, applicants will not be entitled to receive payments from the proposed respondents. Repayment, my submission is that the repayment plus the value given by Mr. Mtetwa and the payment by the respondents will then amount to a greater sum received by the to a greater value received by the applicant. I've had my learned friend speak about the issue of the forfeiture order. He says, well, the issue of this money that was paid back is still subject to a forfeiture order. My submission, my lady, is that it is unnecessary for a forfeiture order to be granted. The money has been repaid. The only issue for determination is there any value that Mr. Mtetwa has advanced in the contract that entitles him?
Let's anticipate let's anticipate what Mr. Mthethwa may say in the main proceedings, right? So there's a point made in the opposition to the joinder that there's a repayment. However, Mthethwa is entitled to payment from digital vibes for services rendered.
That's correct,
right?
yes.
So in these proceedings, you are saying there's no basis to join your clients because of that payment.
Yes.
We get to the review stage. When we get to the review stage, then there's a counterclaim by Mthethwa for money due for services rendered. It's against exactly the amount that has been repaid. So where does then the SIU recourse lie?
In those circumstances, my lady, a ladyship would have made a finding as to what value of the services or what the proper value of the services were. If a ladyship comes to the conclusion that there was no value for the services, so be it. If there is a value attached to the services, my lady would make a just and equitable, will make a just and equitable finding, which may include no repayment. And if that is the case, Mthethwa's claim against Mr. Mthethwa has to fail. And therefore, the value of the 10.6 million will still be with the applicant.
Okay.
But lady, just on the forfeiture order, in terms of the rules of the tribunal, what I've noted is that forfeiture orders are only granted in unique situations where there's a preservation order in place. This is not the case. So accordingly, there is no need for a ladyship to make any forfeiture order.
Yeah, I didn't make any findings regarding forfeiture in the judgment, and I was very careful not to do so.
Yes, my lady. So I'm just going back to to my learned friend, Mr. Curry's argument that in any event, the money is paid by Mr. Mthethwa on behalf of Mateta cannot be seen as a payment because it's still subject to a forfeiture order which has not been made. My submission is it is unnecessary for a ladyship to make a forfeiture order because these are not monies that are preserved in terms of a court order as required by the rules of the
But there's
tribunal.
no appeal that lies against any issue in relation to forfeiture. There's no ground of appeal dealing with that, is there?
No, there
Yes,
isn't.
I didn't make any findings regarding the forfeiture.
Yes, I'm just replying to Mr. Curry. And my lady, I agree with my learned friend. I'll switch my pages here. Who says that the turpitude, when dealing with turpitude, my submission is turpitude is now a non-issue because the monies have been repaid, and that is the case. That is the reality of the matter. My lady, those are my submissions.
Thank you. Thank you very much. We've come to the end of the proceedings. Judgment is restored.
As my lady pleases.
As it pleases you, lady. Thank you.
As the lady pleases.
As my lady pleases.
Thank you.